you.
this
Thank
day.
you.
My lord, this is that matter wherein Lordship had asked us to file the petition and serve on the other side with regard to that movie being, my lord, unilaterally banned. Kerala story.
Now Supreme Court is seized.
No, my lord, that is a different thing. That's under 32 by the producer. That has got nothing to do with this petition, my lord.
No, in that, the challenge is to the Madras judgment, Madras High Court judgment.
Yes.
As well as today, no? Today we read in the papers. Tomorrow the matter is fixed.
So this is different, my lord. This is on the issue that, my lord, there could not have been a ban in view of the CBFC being there, my lord. And there is a judgment of this honorable court which has been upheld by Justice Chandrachud, which is, my lord, on the pat on the point. So I was only beseeching if tomorrow, my lord, Lordship kindly
No,
takes it.
tomorrow it's difficult. You file it.
I have already done everything, my lord, first served and everything.
Monday it will come.
My only difficulty is that Monday I have some personal difficulty.
Tuesday.
The other matters are coming on Monday, my lord. May then all the matters come up on Tuesday, my lord, in that case.
We don't know, but
So that-
other advocates will say, why my matter is not come
Or
out.
if your lordship takes tomorrow, my lord, it will take 15 minutes.
No, tomorrow is not possible. Please, sir.
So then,
Tuesday it will come out.
my lord, Tuesday.
Tuesday is convenient for you.
It's convenient for me, my lord, Tuesday. But only thing, lordship, my lord, if frames, my lord, opinion on Monday with the other matters, then I would be in a difficult position, my lord, to pursue my lords. That is the only difficulty. Although I know this is completely different from the other writ petitions, my lord.
No, then you can argue. If it is different, then those won't. We will not form an opinion so soon.
Only thing is that, my lord, I would beseech, my lord, if lordship, my lord, takes up the matters on Monday and my lord passes the order on Tuesday after hearing me. Because I understand lordships will frame a mind, my lord. So I don't know whether it would be in my favor, even I don't know. With
No,
the other
let your matter also be listed on Monday.
Yes, my lord.
Then probably somebody can make a mention saying that you need to be heard in the matter. We'll do something.
Very well, my lord. I'm grateful, my lord. I'm grateful. May I just give the number?
May it please your lordship, before I begin my submission, my lord, may I take this opportunity to congratulate my lord.
Thank you.
My lord, I'm also mentioning on the self-same matter, my lord, the ban on the movie, my lord. If my lord so apprises, my lord, may it be fixed on Monday at 2 p.m.
No. Timing, we leave it to us. You
Okay.
file the matter, it will come.
We filed it yesterday
Yes,
itself, my lord.
it will come out.
Deeply
My lord,
obliged, your lordship.
one matter, my lord.
Yes.
My lord, one mat is already been filed before your lordship. And my lord, that when the matter is pending, then my lord, knowing that there is a mat before the Hon'ble High Court and at the division bench, then my lord, the party, that means the person, my lord, has been put under arrest, mercilessly beaten, and my lord, yesterday he has been placed in the Alipur, my lord, jail. And thereafter, my lord, that the lawyer moved and my lord, police custody has been given. My lord, the matter is so urgent because that only for filing it, why you have filed it against us? That is the whole complaint, my lord.
No.
Police cannot do in this one manner.
No. This is an appeal from a.
Yes, this is an appeal before your lordship.
What was the order passed by this?
Order passed by it that you have been mercilessly beaten and a case has been lodged against you that it is a loan or such. You go file a petition under section 156 clause 3. But my lord, that the 156 clause 3 is not the proper remedy. The remedy, my lord, the Supreme Court in series of cases have stated that means the writ court or the constitutional court will give, my lord, the guarantee at least that the person's right will not be curtailed. My lord, here in this case, thereafter, my lord, you have proceeded here, and my lord, why you have filed it? My lord, most urgent, my lord, we have already filed it. The matter is pending, and he is in jail, my lord. Therefore, let the matter.
No. If he is in jail, you can move for bail.
My lord, yes, we have moved for bail, but my lord, the hands are tied because ordinary criminal court, my lord, that the police custody has been asked for. Therefore, that he have no other alternative but to file. That well, you do accordingly. We have done it accordingly, and the police custody is there. My lord, that I think, my lord, that the regular bail we have already asked for,
Yes.
and my lord, it has been rejected. My lord, maybe because that there is another reason police custody is there. But my lord, my lord, that the main point is that why I have filed it before the Hon'ble Court in division bench. Therefore, my lord, a case has been cropped up that you have taken loan from such persons, and therefore you have not paid.
All right, you give the slip.
My lord, yes, my lord, let the matter be taken up. My lord, at least for 5 minutes, if your lordship will kindly see. My lord, tomorrow, my lord, at any point of time.
Let us see.
I'm grateful.
We'll call for the file and then see.
My lord, I'm grateful.
My lord, may I permit to file one review application without the certified copy? My lord, my lord, I have applied for certified copy, but it is not. My lord, kindly, my lord, your lordship grant.
Review of our order.
my lord.
In which matter?
My lord, in that matter where the my lord was pleased to direct the authorities to take decision with regard to private tuition by the school teachers, my lord. My lord, we have another my lord, PIL is pending, my lord. They have taken out an application, my lord. It is pending. They, despite knowing that, my lord, they have obtained that order, my lord.
You are not a party in this
No,
matter.
my lord.
You are a third party.
My lord, I have taken out a separate public interest litigation which is pending before your lordship, my lord.
That's correct. We passed an order in a public interest
My
litigation.
lord, my lord, if this order is there, my lord, that our PIL will be.
No. We have not disposed of the matter.
Yes, my lord, disposed of, my lord.
And what is your PAL?
Well, our PAL is that the class 9 to 12 students should be allowed to take private tuition from the school teachers, my lord. And we have challenged the virus of the concerned rule. My
Then there's no problem. You can independently argue it. If you challenge the virus
lord.
of the
Virus, we have challenged.
then this review is not required.
Since, my lord, there is a order, my lord.
You
they are-
get you obtain a certificate copy and then you file it. In the meantime, you move for your
my lord,
PIL
it
to
is
be listed.
appearing before my lords.
It is there in the list. In the monthly list, it
And-
is there. What is the serial number?
I'm just checking, my lord. I'm just.
You give the serial number, we'll try to do it. No problem.
May I have your lordship's kind leave to file 3 appeals, lordship, without the certified copy?
Ah.
This is in regard to a police inaction matter, lordship. 3 orders has been part in the same writ petition, lordship. This is in regard to ragging of a Kharagpur IIT student and subsequently his death. And the investigation has been handed over to a retired CID officer, lordship. Now the last order which has been passed, lordship, second postmortem has been sought by the retired CID officer. Lordship, we want to file an appeal against that order, lordship. The next date for that matter to appear is tomorrow, lordship. They have mentioned the matter. We have applied for the certified copy on 28th, lordship.
This Kaliganj incident.
Pardon me, lordship?
Kaliaganj incident.
No.
Ah.
No. Kharagpur IIT student, lordship.
Kharagpur. And it's an intra-court appeal, is it? That is against the single bench order.
Yes, lordship. Yes.
And who are you?
Lordship, I am for state, lordship. State police.
Police.
Grateful, lordship.
May I have my lord's leave to file an appeal without the certified copy
Hmm.
of an order dated 25th April, my lord?
But may I be allowed to file this intra-court appeal, my lord, without certified copy, my lord?
Yes. Next. Please
I'm
call.
great.
Appellate side, daily list, serial number 1.
Before we start, but congratulations,
Thank
I
you.
not
Thank you. Thank
Lord,
you.
wishes to you.
kindly accept my and my team's congratulations as well, my lord.
Thank you.
But in this matter, Lord, we had preferred an appeal. A stay was granted. But after that, not on the last day when the matter came up on 5th of April, your lordship had directed that the stay order is made, Lord, till the
Continue.
disposal of the appeal and directed that the matter is placed for directions today, my lord.
And
That's why it's appearing, Lord.
how long it's likely to take? Sir?
Lord, I will not take more than half an hour, 40 minutes. Half an hour to 40 minutes. max.
Immediately after vacation, we can fix it.
Any day convenient to your lordship. Any
We are suffering an interim order.
Interim order. We follow that. What is the nature of the interim order?
Lord, the nature of, Lord, it's a final, Lord, the nature of the interim order passed by your lordship is it's a stay. The order which they had got was a writ petition was filed by them challenging a tender. Lord, under which there was a preference.
What is it? Tank truck.
Yes, that's
And all of you are operating. Therefore,
My lord, my challenge in the writ petition was with regard to the vehicles which are firstly not operating and secondly with regard to those which have been placed in a different state, my lord. So, my lord, I am losing out on the business, my lord. My
he
entire,
is operating in a different
my lord,
state.
I may be operating, my lord.
but your profit margin obviously.
Yes, my lord, I have participated in the Bihar tender, my lord, looking at some feasibility of my business. I could have participated in the similar tender which has been issued for Jharkhand or Assam, my lord, where I have been placed. Some of my vehicles have been placed, my lord. My purpose is being defeated, my lord.
All right, we'll fix it up immediately after vacation.
But the first Wednesday, my lord, if your lordship's business kindly permit.
7th, is it? 7th.
Yes.
List the appeal for hearing on 7th June.
Obliged.
But may it retain the position, my lord?
Yes, I think so. It will retain.
Grateful.
No, it won't come under the caption for directions. but it will definitely.
Non-controversial matter, my lord, right at the beginning, it's a good way to start the vacation.
Next.
Serial number 2.
There are 3 matters, my lord.
Hmm.
2, 3, 4. Relating to different periods, my lord.
My hearty congratulations to your lordship.
Thank you. Thank you.
Today,
Mr.
I speechless when I saw I am in a video conference, but I have been restricted here. So I am in a video conference, but I saw your lordship.
I have also saw.
What is this?
My lord, against the adjudication order, we filed a writ petition before the honorable court, my lord.
Hmm.
We said that under section 75 subsection 4, a personal hearing is mandatory, and if it is not granted, then the order vitiates and it should be set aside. Now, my lord, that prayer was it was not considered, and exchange of affidavit was given, my lord. Direction for exchange of affidavit was given, but no interim order. So in the meantime, in the 3 cases, the total demand on account of taxes was 93,35,005 rupees. Out of this, my lord, they have already realized 1,11 lakh from the third party, my lord, that is a PWD on whose behalf I am working.
By garnishi order.
By garnish. Now, my lord, I am unable to run any business, my lord, for want of my operation of the bank account, as well as my lord, entire amount has been stuck, my lord, before the very.
Now your bank account has been freezed.
Yes.
And what is the interim order you sought for in the writ petition?
We will kindly come to
Where is the prayer in the writ petition?
writ petition I have annexed, my lord. Page number 7, prayer.
Set aside the order dated 10th November 2022.
Now, my lord, kindly come. This so-cause notice was not annexed, my lord, with the petition, my lord.
Not to take coercive action, interim order.
Yes.
What is 10th November 2022 order?
But 10th November 2022's order is at page, my lord. Page number 11, my lord.
এটা করছো তো 548 করছো তো 548
11 is the relevant post. On the basis of the report,
But the order says that notice was issued and the assessee did not appear.
my lord, I have
Middle, accordingly, notice was issued to you from DI
DRC 1, my lord.
fixing the hearing on 14/3.
Kindly see, this
But-
is the notice which has been issued. So-cause notice, my lord. Kindly.
These are not annexed.
My lord, it is downloaded from the portal, my lord, but kindly see, have a look, my lord. This is,
Today is the situation is we have already
my lord, kindly see.
served the opposition
Kindly
to
see.
them. We are waiting for the reply. Then the matter is ready for the hearing.
Kindly see the next page, my lord. Kindly see the next page.
Yes.
My lord, please say
I want a copy though.
section under which so-cause notice statement is issued under section 74. Thereafter, date by which reply has to be submitted. 28/10/2022. Date of personal hearing not applicable. Thereafter, my lord, time of personal hearing not applicable. Now, kindly consider, my lord, section 75, subsection 4. It says when an adverse order is required to be passed, then the personal hearing is mandatory, my lord. Kindly see section 75, subsection 4 of the GST Act.
But now, by virtue of a garnishi order, they have recovered the entire money.
On account of tax only, my lord. Tax to the my lord, portion relating to the tax only.
All right. This is an appealable order.
This is an appealable order.
So, in the meantime, why do you freeze his bank account?
More than 30% has been realized.
He could have, my lord, went and appeal, my lord, only deposited 10% of the
10%.
disputed tax, my lord. Today, my lord, he choose not to. He choose not to participate before the authority. He choose not to file the appeal. He chooses to file, my lord, writ petition before my lord, the learned single judge. My lord,
And when
now,
was
my lord,
the writ petition was filed belatedly?
No. Within the 120 days, my lord, from the date of order, my lord.
No. It is
10th,
filed
11th,
on
2022 is the order.
3rd February 2023.
Yes, 10th, 11th, my lord, 10th November 2022 is the date of order. But my lord, in case I have filed the appeal petition, my lord. 10% is the amount which is required to be paid only on to the extent of tax, my lord. Now, in this case, out of these three cases, my lord, total amount of disputed tax is 93 lakhs. And they have realized, my lord, 1 crore 10
But
lakhs.
then you should have filed an appeal.
My lord, what I am submitting, I do not want to lose one forum, my lord. Why I am saying so? Because the personal hearing is mandatory, my lord. Different high courts has decided that if you can't give the personal hearing, even the petitioner
All right.
asks,
Now that you have recovered, why can't you give him a personal hearing?
I will explain all. Yes, my lord.
My lord, if my lord, I concede to the one point, my lord. If he wants to, my lord,
Only one.
wants, my lord,
No, we will
to,
not.
my lord, go into
no,
the, my lord, appeal, my lord. Appeal is, my lord, your lordship knows continuation.
No.
Show cause is there.
It is true that he has not availed the remedy, he has missed the bus, etc. Now that you have recovered the tax, we will direct that this order passed under section 74 subsection 9 dated 10th November be treated as a show cause notice. Within 10 days, he will give a reply.
Yes.
You afford him an opportunity of personal hearing. Decide the matter afresh. Meantime, please defreeze his account.
And my lord, kindly protect us, my lord.
Yes.
Protect the revenue, my lord. Then my lord, whatever has been, my lord, recovered, but that
No, that will abide by the fresh orders.
kindly, my lord.
But my lord, suppose, my lord, if the order goes in against me, my lord, then again I have to pay 10% of the tax in this.
No, that won't be required. That won't be required. No, the entire liability has been set off. At that stage,
Yes.
we'll think. Three matters,
Yes,
Three
three
matters,
matters.
2, 3, and 4, my lord.
but different periods.
Different periods. My lord, may
These appeals have been filed against the order passed by the learned single bench, declining to grant any interim order and directing the respondents to file their affidavit in opposition within a time frame, with liberty to the petition appellant to file a reply thereto. The order impugned in the order impugned in the writ petition is an order passed under section 74 within bracket 9 of the WBGST Act 2017 within bracket the Act. Admittedly, the said order is an appealable order. The appellants did not choose to file an appeal, but approached the learned writ court on the ground that opportunity of personal hearing has to be mandatorily granted in terms of section 75 within bracket 4 of the Act. And this having not been granted, the order dated 10th November 2022 is liable to be set aside. The fact remains, that during the pendency of the writ petition, the entire amount which was demanded in the three orders passed by the respondent, which were impugned in the writ petition, has been fully recovered, if not more than the amount which was demanded, except penalty
and interest.
The learned counsel appearing for the respondent state points out that notice was issued fixing the hearing date on 14th March 2022, but the appellant failed to appear on the said date and also did not appear on the adjourned date, which was fixed on 25/3/2022. The learned advocate for the petitioner, on the other hand, would submit that in the show cause notice dated 28 September 2022, in the column regarding details of personal hearing, it has been mentioned as not applicable. Therefore, it is submitted that the mandatory statutory requirement of affording an opportunity of personal hearing having not been granted, the order which was impugned the writ petition is liable to be set aside. At the request of the learned advocates on either side, the writ petitions are taken up for disposal along with these appeals. Considering the peculiar fact situation in the instant case, namely that by way of a garnishee order, the entire tax demanded from the appellants have been recovered, we are of the view that the revenue will not be prejudiced if an opportunity of personal hearing, if a fresh opportunity is granted to the appellant to put forth his submissions. The full stop. The submission of the learned advocate appearing for the respondent state is that the interest of the revenue should be protected. In our view, the interest of the revenue has been sufficiently protected in as much as the entire tax demanded under the three impugned orders have been fully recovered by way of garnishee proceedings. In the light of the above, the writ petitions as well as these appeals are disposed of by directing the appellant to treat the order under section 74 within bracket 9 of the WBGSC Act 2017, which were impugned in the writ petition as a show cause notice. And the appellants are directed to file their objections to the notice within 15 days from the date of receipt of the server copy of this order. On receipt of the objection/reply, the assessing officer, the Deputy Commissioner State Tax, Bardhaman charge, shall afford an opportunity of personal hearing to the appellant or their authorized representative and pass fresh orders on merits and in accordance with law. The amounts, so far, amounts which have already been recovered by way of garnishee proceedings shall abide by the fresh orders to be passed in terms of the above direction. In the light of the fact that the entire tax demanded in the three orders has been recovered, the respondent authorities are directed to defreeze the bank accounts of the appellant.
Well, as well as third party garnishee is also there.
Third party garnish.
One more submission. Date of order are different, my lord, in three cases.
2911 is one case. Another case,
Another, my lord.
you give the date.
MAT 549. My lord, date of order is 2nd December 2022.
549 is
2nd December 2022, my lord.
2022. Then,
And in 551, my lord, date of order is 10th November 2022.
and MAT 548 is 2911.
Yes, my lord.
Yes, I admit it. All three appeals disposed of.
I'm grateful, my lord. Once again, my lord, I'm conveying my
Thank you. Thank you.
Serial number 5.
Yes, sir.
I again congratulate your lordship, my lord. But we had a tremendous harassment by members of the bar. Half a kilometer away from the court, my lord, we had to park our cars. And we couldn't, we had to go on the way, my lord. This is how the administration has totally, my lord, strangulated the lawyers, my lord. We were totally punished today in the morning. There was no car parking facility. We had to go to the Ganges, bank of the Ganges to park our car, my lord, from here. This was never happened. We always the part of the feel as a part of this institution, my lord. We were, my lord, segregated from the institution today in the morning. This is, of course, my lord, should not be repeated in future, my lord. Be that as it may, my lord. My lord, this is the impugned order, your lordship will kindly see. This is something, my lord, where the allegations were made of fraud committed by the Director of Fire Services. Page 188, the impugned order in the stay petition. The court's finding also was wrong in many aspects. The court was very hurriedly disposed of because he was under tremendous pressure. This was a motion stage, my lord, which came up before the court, and the court said that the old matter hearing are disposed of this way. We have been asked to go to 156.3. When admitted position, the Director of Fire Service has committed fraud. He has said that whatever I have done is wrong. He has given a name of a person, my lord, who has been given the color of a civil engineer, architect. Although the petitioner's name was utilized for the purpose of getting a fire safety certificate. That was a story of 2019. So I came up before this court by filing a writ petition that fraud is committed. I was never a civil engineer, nor did I give any signature there. Therefore, the entire process leading to the issuance of the fire safety certificate was polluted.
Let us see the certificate 26th August 2019.
That is with them. Let them produce the certificate. Their averment is there. I take your lordship to the affidavit made by in the affidavit itself. Affidavit of the,
No, in the writ petition, you want a writ of certiorari to quash that certificate.
yes,
But you
let them
don't-
produce it, my lord.
You don't have the copy of the.
No, nothing has been given, state even did not appear.
And what was the stand taken in the affidavit in opposition?
When we made the allegation, my lord, the fire safety authority said that whatever the allegation is made, my lord, probably we committed mistake in using the name of the writ petitioner. Although that particular mistake, my lord, ultimately culminated in issuance of a certificate of fire safety. And he had said subsequently, my lord, we have rectified that by giving a new name of engineer. Why he is implicating him with that B.Ed college? B.Ed college is commercially being allowed to be run there only for fetching money for the purpose of giving a training certificate. Why, my lord, this particular fire safety authority will be, my lord, joining hands with those class of unscrupulous set of persons, my lord, operating business by making false allegations? I have made the FIR in Newmarket police station, my lord, no investigation has been held. Why should I go for 156(3)? Because the director of fire service is involved, by allegations are there, and his inquiry is to be held by the police authority. State did not turn up even. An application, my lord. An application, my lord, was entertained by them, which speak of the proposed building. And within 10 plus 4, 14 days, proposed building converted into a complete building. It's 3-story building is completed, and accordingly, my lord, the college is running, and he has given a fire safety certificate in 14 days. Where he is saying once, now he is coming forward by saying, no, proposed, I have committed wrong. More than once, my lord, he has used the word proposed.
In the certificate, the writ petitioner's name has been issued.
Yes, that application is there. That is not the certificate. That application is there. Name of the petitioner has been utilized. That is at page 40.
But in the writ petition, there is an averment saying that he was
Not to look at page 49.
at the time of establishment, the repair and renovation of the dilapidated building, your instant petitioner is engaged as consultant civil engineer and labor contractor.
No one, that is absolutely wrong. Lord, you kindly come to page 49. This was submitted on 27th of August 2009. And in September, my lord, the fire safety certificate license was given.
No. This is, I read from your writ petition, page 29, internal page 5.
Yes.
Please see the third line, at the time, or second line, at the time of establishment, the repair and renovation of the dilapidated building, your instant petitioner is engaged as a consultant civil engineer and labor contractor. In all probabilities, he signed the form.
As I established the repair and renovation of dilapidated building, your instant petitioner is engaged as a consultant civil engineer and a labor contractor.
Yes. So therefore, you are part of the contract or construction, etc. But where is the question of forgery? And
this has been admitted to be a forgery. Page 49, kindly come.
Page 49.
Yes. That was a story of 2004, and it is a story of 2009. When 2009, a fresh application for fire safety certificate has been used.
19.
Sabir Ali's name is there.
Sir, you are a consultant civil engineer labor contract. You are engaged for doing some repairs in the building. Your name has been shown as architect. Probably that
I
is
am
wrong.
not an architect.
You are not an architect, but you are involved in the building activity.
I am not involved in the building activity. Previously, in 2004, I made some renovation. In 2004, old building, I made some renovation. I am not a part and parcel of the institution. They have admitted it, and my name has been used. That has been
Page 48.
scored out.
Page 48.
Kindly come to page 48 for once. I have made an application under RTI, page 48, and accordingly, these documents have been I have procured. That is their document.
Application made by Sabir.
This application was made by Sabir Ali in 2019. And accordingly, this particular 27th August 2019 document has been disclosed to us. And this document ultimately culminated in issuance of a fire safety license, my lord. Lordship will kindly come to page 56. That when application was made on 27th August 2009, 26th August 2009, they say there is a proposed building. A building is proposed. And page 62, my lord, the license has been granted. All these have been done on the basis of the application of 27th August 2009, where my name has been utilized. Subsequently, my lord, they gave an affidavit before the court that the engineer's name, fresh at 87 page, my lord, Director of Fire Services affidavit. However, in the fresh plan, where is the fresh plan is coming? Let them disclose it. Come with the clean hand, let the records be produced before your lordship. I am not praying anything further today. Let the records be produced by the Fire Safety Department, the Director of Fire Service. Last line of page 87, Director waived the fire safety recommendation on 9/9/2009. What does it mean? I don't know. He was waived it. Through offline mode, as the concerned authority installed down commerce system along with the terrace fire pump reported in the inspection book. And after that, the fire safety certificate was issued on 10 September 2019. 27th August, I applied fire safety on 10 September 2019. No inspection. Was the fire safety arrangement. Now they are proposing to make certain specific construction in the particular fashion and manner. Page 57, Lords, you will see. Open space and approach construction, mode of construction, everything was directed to be followed. Otherwise, no fire safety license can be given. And that is a massive work. Whether the satisfaction is there or not about the construction.
What is LBS?
Licensed building structure. Surveyor.
Surveyor.
Licensed building.
Licensed building surveyor. So they admit that in 2004, the writ petitioner's signature was there, application. But in 2018, fresh plan. Subhajit Bose is the senior planner. Your name was not there.
That let them produce that plan. That plan is not disclosed anywhere. That is the only plan, manner I have said in page 49, which was accepted on 27th August 2009. In my regime, my lord, we have never applied for fire safety license. That was accepted on 27th August 2009.
No. You are not associated with the building after 2009.
So after 2004.
After 2004.
My lord. After 2004.
May I, sir?
Ah.
We are appearing for the state respondent, Mirror.
Ah.
We are having written instruction.
Ah.
I am handing over. Initially, on the basis of the complaint, two complaint has been filed. One complaint has been filed in the New Market police station. Other has been filed in the local police station within the jurisdiction of Purvavati. In both the police station, the allegations are common. It appears from the allegations that his name has been utilized or used for the purpose of obtaining the fire license. What was his status? His status was he was the one of the member or the associates of the same college. And he was there as an engineer, civil engineer. Initially, during the course of inquiry, the inquiry report has already been annexed with it. It appears from the report that there was a dispute between the management and the person concerned. So, he started distancing from the management his grievances against the president of the college, B.Ed college. So, he is trying to create a difficulty by keeping a pressure on it, by making out a story, which is reveals from the preliminary inquiry which was conducted by the police. He made a Milord representation to the Grievance Cell of Kolkata Police, on the basis of which Milord special care was taken by the Milord the Grievance Department, by Milord conducting the inquiry by the officer who was appointed. On the basis of the report, it appears, Milord, kindly see the third, Milord, the report of OC section J2.
Yes.
This is the Milord. Kindly see, during the inquiry, second paragraph, during the inquiry, it could be learned that the incident dispute is associated with the allegation of the manipulation made by the informant, such and such in respect of the safety certificate issued by the doctor, B.R. Ambedkar B.Ed College situated in such and such, and which has been accredited by the National Council for Teachers Education, New Delhi, having such and such. In course of the inquiry, contacted Gopal Das, such and such, of the administrative officer of such and such, and the president of the same college. It could be learned that the college has been inaugurated on the 16th of January 2007 with all sanction from all concerned. The present complainant such and such is a civil engineer who prepared the plan for the college, which was converted from the old house of erstwhile Jamindar of Devra. And after the start of the functioning of the college, a dispute was cropped up with the instant complainant such and such and the present administrative body of the college over the issue of the different administrative matters, and subsequently, Milord the appellant was disassociated with the functioning of the college, and which is running smoothly since then. Then Mr. Das, Sri Das, was vehemently denied having regard to the issue alleged the forgery of the fire safety certificate issued by the college. And Milord, the fire safety authority did not make any complaint to the authorities, police authorities, saying that by manipulation, by placing wrong documents, Milord, a certificate has been obtained. This is between a
But one party in asking, my lord, he has disclosed to your lordship.
Actually, this is very evidently clear, sir. You are associated with the project or the college or the building.
My lord, kindly, my lord.
Something happened between yourself and the other man. Now you are trying to use some.
This is story made out by them. This is
No. It is.
Let them produce the evidence in support of that. I am a member of the
we are
management
not
committee.
here, sir. Writ court is not for that. Writ court is not for that.
Writ code is,
My
he
lord.
has said 2007,
No.
the
If it
college
is-
started functioning. Man, may I accept the submission of my learned friend, Mr. Datto. He has said 2007 onwards, college started functioning. That means B.Ed courses going on, B.Ed certificates are to be issued. But how the 2009,
Why you are a civil contractor, license building.
2019, the college
I-
can apply for
You
fire
are-
safety license.
It is clearly attempt to do something to the college for certain other personal reasons.
But
Yeah.
lordship will not get that impression against
Yes,
me.
sir. Sorry.
Because-
My lord,
The
I am appearing in person. I am the secretary of the college, also degree holder from the civil code. There is a nexus between the fire safety department and some imposters. Imposters are applied for fire certificate to hijack the college from our society. We have only 69 decimals of land. We have only 69 decimals of land, but building area is more than 2 acres. That is near about High Court building. And proposed buildings started 10th
September 2019.
are completed within 14 days. And not only that, the fire safety certificate issued in the day of Muharram, in the day of a national holiday. This is a nexus, an unruly nexus. And the forgery, manipulation, everything has done. We are the authority of the college. He is the president of the college. I am the secretary of the college, and degree holder, civil code degree holder. They are trying to hijack the college.
Now, what is the dispute between this person and the college?
Trying to.
No, I tell you, Lordship, my lord, I am appearing for the respondent number 12. I was the president of the managing committee of that college. Now, my lord, the persons, my lord, who are running this college now, who are imposters, my lord, they ousted us from the college. Now we filed a suit. My lord, the suit was decreed in our favor, my lord. We have annexed at page 107 of this writ petition. 148, my lord, is the relevant operative portion of that order. My lord, may I just placing this 148?
Sorry.
It was filed by my learned friend, who was the secretary. The last 2 lines, hence it is ordered that the suit be and the same is decreed on contest against the defendant number 1, 5 and 9 and as ex parte against the rest defendant. It is hereby declared that the B.Ed college, namely Dr. B.R. Ambedkar College, is run by the elected governing body of the plaintiff society, namely Malighati Dr. B.R. Ambedkar Society for Advancement of Learning and Health. The defendants are hereby restrained permanently from the interfering with any decision of the governing body of the plaintiff society in running of the aforementioned B.Ed college, particularly in respect of its administration, management, operating the schedule mentioned bank accounts of the college without due course of law. Considering the facts and circumstances of this case, I make no order for cost. Now, my lord, the execution case is pending. In the meantime, my lord, the NCTE, National Council for Teacher Education, my lord, they are the authority, my lord, to give recognition to this institution. Now, by the 266th meeting, my lord, they, my lord, took a decision, my lord, whereby the recognition was cancelled due to, my lord, the present managing committee of that college, my lord, failed to produce any fire certificate, my lord. Kindly consider this 266th meeting. Well, kindly consider the date of this meeting, 31st of January 2019, at the top of this document, proceedings of 266 meeting of the ERC, Eastern Regional Committee, NCTE. Now, my lord, kindly consider the next page. Resolution number 36 at the top of this page. Dr. B.R. Ambedkar College, the college in question, B.Ed private, the West Bengal University of Teachers Training, Education, Planning and Administration. Then this is the decision of the National Council for Teacher Education. After considering and examining the application along with the documents submitted by the institution, agenda note, NCTE Act, NCTE regulations, including norms and standards, guidelines received from NCTE headquarters from time to time, VTR and no reply in response to SCN, the committee discussed the matter in detail and observed as under. 1. Show cause notice under section 14(3)(b) were issued on 23rd of August 2018 and 19 September 2018 for submission of fire safety certificate issued from the competent government authority. The institution, with a letter dated 9th of October 2018, expressed inability to submit the fire safety certificate. The institution is still deficient on the above ground. Then, in view of the above, the committee decided as under. The committee is of the opinion that application bearing code number AP such and such of the institution regarding recognition to B.Ed program is refused under section 14(3)(b) of the NCTE Act 1993. Now, this decision, my lord, was taken on 31st of January 2019, and this was, my lord, communicated, my lord, on 22nd of February 2019, my lord. This is the decision, my lord. Formally, it was communicated, my lord. Your lordship will find second page, serial number 10. Now, therefore, as per the decision of Eastern Regional Committee, the application submitted by the applicant for grant of recognition for B.Ed. Now, your lordship, kindly see the date of the application, my lord, for fire certificate, which is at page 48, my lord. My learned senior friend, my lord, filed an application under the RTI Act. Kindly consider the RTI application was made on 21st August 2019 at page 48 of the writ petition. This has been done in a surreptitious manner, my lord, subsequent to this decision taken by the NCTE, and the fire certificate has been obtained, my lord, fraudulently, my lord, by these imposters. These are my submissions. Therefore, my lord,
what has the institution done? They have not applied for fire safety.
No, my lord, the fire certificate was given to this institution and they, my lord, submitted it before the NCTE, and pursuant to such submission, my lord, the NCTE granted recognition. The question is, my lord, that whether the certificate issued by the fire department, which was issued on a holiday, a national holiday, there was a Moharram, my lord, on that day, and on that day, my lord, the certificate was issued. Now, the challenge, my lord, thrown by my learned senior friend is that whether, my lord, the procedure or, my lord, this application was a valid application. This is one. Second, my lord, the decision-making process. There's a total, my lord, a gray area, how they obtained the certificate within a short span of time.
No, you are in management now.
No, we were ousted. Although, my lord, that decree is in our favor.
That's in execution.
Yes, our execution case is pending. We are now outsiders, my lord, in spite of we are
my lord,
No, what does the petitioner gain out of this
my lord,
litigation?
every seat of a B.Ed college, my lord, cost around, the admission fee is around 75,000 to 1 lakh.
Now, according to him, the fire certificate, was obtained by filing an application using his name when he was not at all connected with the project.
Yes, and this is one of the preconditions, my lord, for getting the recognition from the NCTE.
Exactly.
On this ground, my lord, it was rejected. Thereafter, my lord, in a surreptitious manner, my lord, this certificate was issued because that was the only ground for non-granting of that recognition.
So in fact, this rejection of the NCT approval, you are quite happy with this.
My lord,
You
today,
are not-
my lord, I
you are
don't
not
want,
able to
yes,
gain ground.
yes, my lord, your lordship, my lord, today, my lord, I don't want to run this college, which was our college and which is our college, my lord. I don't want that the college is, my lord, is being run by some imposters, my lord, who doesn't have any authority to run this college. As at least, my lord, that is the verdict of the civil court.
Yes, sir. What do you like to say?
But I am also on the view that since the entire process leading to issuance of the fire safety license was procured by exercise of fraud, and which is the pivot for granting them permission to.
Then, therefore, you are indirectly supporting the president and secretary.
I proceeded, then they
Because
came forward to
obtained a
support.
civil court degree, they are not able to enjoy the fruits of the degree. Execution is pending.
Well, that is their headache, my lord. I am not on the execution of the case because I am not there.
You do your construction work, sir. Why are you getting into this dispute?
But my view, that particular document that used for the purpose of granting
All
this
right.
particular,
We have
and they have admitted it to be wrongly done.
We have considered.
Lordship, that is forgery, manipulation.
Yes.
Money power has been used.
This intra-court appeal by the writ petitioner is directed against the order dated 21st March 2023 in WPA 6562 of 2020. By the said writ petition, by the said order, the writ petition was disposed of by directing the by observing that the petitioner and the private respondent number 11 may approach the concerned magistrate under section 156 within bracket 3 of CRPC in the event they are aggrieved by any decision of Newmarket Police Station or Debra Police Station in refusing to register an FIR. After elaborately hearing the learned advocates for the appellant and the private respondent, as well as the learned advocate for the respondent state, we find that the attempt of the writ petitioner is to intervene in a dispute with regard to the administration of a B.Ed college. Admittedly, the private respondent had approached the civil court in suit number 61/2013/40 of 2007 on the file of the third court, Paschim Midinapur. No, sorry, on the file of the civil judge within bracket senior division, third court, Paschim Midinapur. And a decree has been obtained on 1st November 2019, and it is admitted by the private respondent that that execution proceedings are pending. In the interim, the petitioner approached the court, writ court, by stating that his name has been illegally used for the purpose of obtaining a fire safety certificate. In any event, the recognition of the college was not granted by the National Council for Teacher Education on the ground that they are unable to produce the safety certificate. Thus, we are of the view that a private dispute is sought to be given a color of police inaction. Therefore, we find there is no ground to interfere with the order passed by the learned single bench. Accordingly, appeal fails, is dismissed. Sorry, sir. Next.
Serial number 6.
Pen is missing.
Opinion in this matter, but I think this is the education matter.
Education.
Wrongly it is appearable.
Okay.
And it will go before court number 11. It's the pension matter of primary teacher.
So it has to go before the other.
Court number 11.
Where do you find the classification? No, no, you see. Subrata. Yes. See the subject category code in this case. Sub. No, you see the code number 4.
You have mentioned in the presentation form to fall under group residuary.
That clerk has.
To show it to.
Actually, this is the primary.
But it is
Shown
you
as
have
a-
filled up
But
the
I-
presentation form to be
I
under the
admit
heading.
it. But I
residuary.
admit it. There is some wrong. But if your lordship takes up this matter, but I have not.
Oh, no, why you should-
I have not.
The learned advocate appearing for the petitioner submitted that by
But leave may be granted to correct.
inadvertence, while filling up the presentation form, the case has been shown to fall with under the category residuary, whereas it is a group two matter. The learned advocate for the petitioner is granted leave to amend the presentation form, and thereafter the matter be listed before the appropriate honorable division bench.
Diploma.
Next.
Serial number 7.
Yes.
I'm appearing for the appellant petitioner, my lord. My lord, before placing the facts, my lord, entering into the merit of the case, my lord, I precisely state, my lord, the brief facts, my lord, leading to filing this appeal, my lord.
Very good.
My lord, what happened, my lord, that the state of West Bengal, my lord, Directorate of Health, my lord, invited a e-tender, my lord, for the supply of surgical latex gloves, my lords, to the various hospitals in the state of West Bengal, my lord.
Very good.
The petitioners, my lords, one of the manufacturer of latex surgical gloves, my lords, participated in the bid, my lord, and the my lord, the evaluation committee, my lord, rejected the bid, my lord, on the ground, my lord, that the petitioner did not apply for license before 30th September 2022. And the same, my lord, on the similar ground, my lord, another bidder, my lord, Vijayalokhi Healthcare Surgical Limited, my lord, his bid also rejected. Then, my lord, thereafter, my lord, in a technical, my lord, financial bid, when it was opened, my lord, then this Vijayalokhi Healthcare Surgical Limited was allowed, my lord, and the petitioners was denied, and ultimately Vijayalokhi was awarded, my lord, contract, my lord, and work order was issued. Against this action of discriminations, my lord, the writ petitions was filed, my lord. That writ petitions was moved before the learned single bench, my lord. The learned single bench, my lord, refused to pass an interim order on the ground that the facts submitted by the writ petitioner did not entitle any interim relief. Against that, and my lord issued a directions, my lord, for servicing a notice upon the Attorney General, my lord, because I have already also challenged an administrative circular, my lord. So, my lord, on the two grounds, my lord, that, my lord, the refusal of interim order and against the service of the notice, my lord, upon the Attorney General, because which is not required, my lord, under the law anyway, my lord, then I prefer an appeal, my lord. That appeal is still pending, my lord, running in the list. My learned junior several occasions mentioned the matter, but since the business of the court didn't permit, so therefore the appeal could not taken up for hearing. In the meantime, my lord, that the matter has come up before the learned single bench, my lord, on the returnable date. Then 1 week time was given to my learned junior. Then after 1 week, he insisted his best, my lord, to mention the matter, but could not get the matter posted in the list. Yes, my lord.
What is the appeal number? It's running in the monthly
Yes, my
list.
lord, that is also running, my lord, against the interim order, and it is a final order. And what happened on the second occasion, so when the matter came up for hearing, dismissed. My lord, I invite your lordship's attention.
No, we
My
read
lord,
the order.
my lord, yes, my lord, that the judicial, my lord's propriety, my lord, demands, my lord,
No,
that
as against refusal to grant an interim order, you filed an appeal.
yes, yes.
But you should have been able to convince the court, the division bench, to grant an interim order. But division bench probably ordered notice.
No, because division bench, my learned junior mentioned on several occasions, from the mentioning list to Rapier, he explained the urgency in
All
so
right.
many words.
Now,
Yes.
the prayer sought for in the writ petition is to quash
Yes,
the.
Then I place the case on merit, whether I was entitled to have an interim order or not, Then, I invite your lordship's attentions at page 191st, as 191st. 1 minute. At page 190, This is a bit summary notice, Shortfall notice, At page 190. This is a notice in respect of shortfall, Then, come to, at page 193, Top, the writ petitioners, Safecare Roberts Private Limited. MD observations part, findings. Right hand side, MDM and M3 not submitted. Applied for MDM in MD3 after 30th September 2022. Then, serial number 21, Vijayalakshmi Healthcare Surgicals Private Limited. MDM or MD3 not submitted. So similar situations. Both the bid has been rejected, Then, your lordships come to page 210. 209, it starts from 2009. Then, relevant part as 2010, This is a, financial bid, summary notice findings, said to 2010, Safecare Rubber Private Limited. Your lordships have got it at page 210. Fourth item, third item from the top. Safecare Rubber Private Limited. Rejected bid to MDM3 not submitted. The bidder sent communications through email dated so that they applied in MD3 on 31st October 2022 after his stipulated date of 30th September. Then Healthcare, Vijayalakshmi Healthcare, whose bid was rejected in Techno commercial bid. Financial bid may be opened. Same situation. My bid was not accepted, but Healthcare's bid was accepted and he was issued work order.
But what was the cutoff date fixed for applying for MD3?
MD3, what happened, Then there is a background. I will explain, what happened,
Assuming assuming for Vijayalakshmi Healthcare, according to you, the illegality has been committed.
Yes.
There cannot be any equality in illegality.
Yes, but if any orders, because the whole evolution process, then it has been vitiated because he was given the work order. So what will happen,
But by now,
No, before issuing the work order, I approached before the writ court, and I also, had produced all these records, along with the writ petitioners, and the court find, that the facts submitted by the writ petitioners did not entitle to any interim relief. So I had a very strong privacy case.
See, that is one ground is that so far as Vijayalakshmi Healthcare.
Yes, and another, yes, page 83, I invite your lordship's attention at page 83. That's the administrative circular. This is also under challenge, At page 83.
Yes.
Yes, Then, I'm reading out, 30th September, The Ministry of Health and Family Welfare has published notification by SO dated so specifying all medical devices under sub-rule 4 of Rule 5, Section 3 of the Drugs and Cosmetics Act 1940, which is effective from 1st April 2020. In order to regulate all the medical devices, Ministry of Health and Family Welfare has published so dated so for regulations of such devices in phase-wise manner as per the notification, as per the case of A and B medical devices will be under licensing regime from 1st October 2022. In the meantime, representations from various associations and stakeholders have been received by this office requesting that the business continuity should not be disrupted due to the implementations of licensing regime with effect from 1st October 2022, Class A and B medical devices. In view of the above, it has been decided that in case of an existing manufacturer who is already importing manufacturing of any class A or class B medical devices has submitted application to Central Licensing Authority or State Licensing Authority on or before 30th September 2022, as the case may be, for grant of import and manufacturing license in respect of the said devices under the provisions of MDR 2017, the said application shall be deemed valid, and an importer and or manufacturer can continue to import manufacture the said device up to 6 months. So this time, my lord, was extended, my lords, only, my lord, those who applied on 30th September. This circular was issued on 30th September at my lord, in the bottom, my lord, at 8:41 p.m., leaving only 3 hours times, my lord. So therefore, this circular,
these are all matters which are outside the purview of a writ jurisdiction.
no, my lord, no.
No, the Ministry of Health and Family Welfare, for some reason, it fixes a cutoff date.
Yes, my lord.
You are well aware. Anytime any order passed by any authority fixing a cutoff date, there will be one set of people who will be affected.
My lord,
So therefore,
yes, my lord, I agree.
One set of people are bound to be affected.
No, yes, my lord,
The age of retirement.
yes,
Suddenly they rolled back the age of retirement.
yes.
Then they said they fixed a particular cutoff date. Obviously, if the fellow was born one day later, you would have got the benefit.
No, my lord, yes, yes,
So that is
Nataras,
not
my
a
lord,
ground.
because as your
And
lord,
in our wisdom,
in my lord series of cases, my lord, that there must be a reasonable nexus, my lord, between the objectives and the circulars, my lord.
this,
But here, my lord, my lord, this life of the license extended, my lord, for 6 months.
you apply for the next tender.
Because no, my lord, because no licensee, my lord, because no manufacturer was permitted, my lord, to participate in the bid, my lord, because they didn't have any license. Only on the basis of this document, my lord, they got the life, my lord, extended for
Correct.
6 months.
Correct.
So I didn't, my lord.
Because you applied 1 month later.
No, that's right, my lord. But my lord, what? Because, my lord, that is why for implementations of that, my lord, representations made by the stakeholders, and that was considered and issued on 30th September.
No,
Is it reasonable, my lord, that my representations of the association stakeholders, that was considered and decided only on 30th September, my lord, and that too, my lord, only 3 hours times giving.
What is the stage of the tender now?
Tender, my lord, now work order has been issued, my lord, but my respectful submission, since it is a medical device, my lord, I don't want to disturb, my lord, that supply, my lord. Let the matter be decided on merit, my lord, that the arbitrations cannot be allowed to be perpetuated.
We will decide it right way.
So yes, my lord, then my lord, within 3 months, my lord, they will retender, my lord, but they will continue supply. My lord, that might be, my lord. Otherwise, my lord, as
No, has your license been renewed now?
yes, my lord.
So we will say that in the next tender notification, you will be entitled to participate.
So that my lord, automatically, my lord, I will have the right. my lord.
Yes.
But
So
my lord,
therefore you don't require that liberty.
There, my lord, apparent on the face of the record, my lord, that the evaluation committee, my lord, had acted arbitrarily, my lord. Then what is the necessity, my lord, to have the evaluation committee, my lord? So, my lord, that the Vijay, who issued the work order, my lord, he didn't have any eligibility criteria like me, my lord. I will be rejected and he will be, my lord, given. So, my lord, things are similarly situated, should be treated alike, my lord. I cannot be treated discriminatorily,
Yes,
my
Mr.
lord.
Ghosh, what
That
is?
is a case of discrimination. So that's, my lord. And the second point, my lord, that circular, my lord, that is
That we will
not case,
consider.
my lord.
That we will-
Because as your lordship is aware, I have got the judgment, my lord, that any administrative actions, my lord, in hot haste, my lord, is presumed to be mala fide, my lord. So, my lord, that this was issued only on 30th September in the night of 8 p.m. and stating that those who apply on or before 30th September only they will be given this benefit, my lord. This is a beneficial circular, my lord, for all the manufacturer, my lord. There may not
No,
be
the
really
word-
any discrimination.
Word used is
Yes.
has submitted application.
Yes.
So if you had submitted an
Then, my lord,
application,
yes, my lord, I'll invite your lordship's attention in the middle portion, my lord. In the meantime, representations from various associations and stakeholders have been received by this office requesting that requiring that the business continuity should not be disrupted due to the implementations of licensing regime with effect from 1st October for Class A, B medical devices. In view of the above, it has been decided that in case if an existing employer applied before 30th September, that was issued on 30th September. That's my respectful submission before your lordship, because this benefit was given, my lord, by this circular only on 30th September.
probably what would have, according to you, what would be reasonable is whoever has applied and the application has not been rejected will be entitled to. That should have been a reasonable approach, according to you.
No, because my respectful submissions is this, my lord, that the licensing regime, my lord, what happened, my lord? There was no license was required, my lord, prior to 2020, my lord. After 2020, my lord, it says that rule says that all medical devices are required to have license, even except certain medical devices that mentioned in the 8th schedule. So we are not 8th schedule, so therefore we are required to have license. So initially 18th month's exemptions was given. And in case of classified B groups, that is for us, my lord, that exemptions was given for 30 months, my lord. The 30 months is to expire, my lord, on, my lord, 30th September 2022, my lord. Then stakeholder, my lord, so that the business continuity may not be hampered. That is why representations was made. Stakeholder gave the representations, and on receipt of the representations, considering their case, decided only on 30th September. That's my respectful submission. So I was, my lord, this opportunity is absolutely meaningless, my lord, because in the midnight at 8 p.m. only 3 hours times, my lord, up to 12 p.m. So one can, my lord, it's not possible to upload all this information, my lord, for having a license. So this is utter, my lord, sufferings from my lord, arbitrariness, my lord, and at the same time, my lord, protest, my lord, in protest actions, my lord.
Any judgments you want to show?
Yes, my lord, I'm relying, my lord, the judgment.
You show us the latest judgment.
And apart from that, and the one hottest, how that I'll show, demonstrate also, even in the tendering process. Apart from this, then how, my lord, this was done, my lord, at page, my lord, 210, my lord, 211.
10 at the bottom, digital signature.
Oh, at the 10 at the bottom, digital signature, my lord, that my financial bid, my lord.
Uploading time of the
This is the uploading time of the bid summary on, my lord, 10th January 2023.
The time is
2
9 minutes,
2 p.m. 9 minutes. Then, my lord, on the same day, my lord, next page.
forwarded by the
Yes, my lord. This was forwarded, my lords, through email, my lord, at the next page, my lord, at, my lord, on 10th January 2023 at 2:10 p.m. I was invited clarifications, my lord. Then, my lord, clarifications, my lord. In case of any clarifications or feedback, you may contact tendering inviting authority, my lord. So I was invited for clarifications, my lord. Then, my lord, next page, my lord. My lord, I do not know whether this page is readable or not, my lord. I have got, my lord, the press copy, my lord, for your lordship, my lord, so that it could be read out. I tender my apology, my lord. This is not readable, my lord. That at the top, my lord, that 10th January, third line at the top, 10th January 2017. Only 7 minutes, after 7 minutes times, my lord, that the work order was issued to Vijay Lokhi.
That is the time for clarification.
So where is the time for clarification? Why this hot haste? Any administrative action in hot haste, my lord, max, my lord, malafide, my lord. Judgment below the.
Generation time. Generated date and time. Yes.
Yes. 2006, my lord. 2004, my lord. Volume 2 SCC, my lord. Paragraph 24 and 25. And 25. The impugned order was proceeded by a direction by the Home Minister on 7th September 1996. A change in opinion came into being only upon change in the holder of the office, and that too within a few days. Not only had the matter not been admittedly placed on the agenda of the meeting dated so and so, the same was considered showing undue haste. In SP Kapoor versus State of Himachal Pradesh, this court held that when a thing is done in a post-haste manner, malafide would be presumed, my lord. So, my lord, in my case, my lord, that exactly happened, my lord. Only 7 minutes times, my lord, work order issued, my lord. I was given, invited, my lord, for, my lord, clarifications, my lord. Then, my lord, 1 minute. Yes. Then, my lord, 2006 11, my lord, 2000 volume 11, reported in SCC, paragraph 71, 72, 73. দাঁড়াও ভাই। এক মিনিট, হ্যাঁ ঠিক আছে, তুমি সব পাবে, তুমি no matter. হ্যাঁ হ্যাঁ, না না ঠিক আছে, 71 minute. Furthermore, a decisions in undue haste was taken so far as the nominated officers are concerned, whereas a notice containing 90 pages was sent to the Chief Secretary of Punjab on 22nd May 2022. The service of all the officers were terminated on the next day. Apart from the materials which have been relied on in the report, no further evidence was probably brought in between 23rd May 2002 and 24th August 2022, when the service of the executive officers were terminated. It is thus furthermore beyond anybody's comprehension as to why actions has to be taken in undue haste. We do not intend to suggest that in any emergency it was not permissible, but we have not been shown that any such emergent situations existed. It has in any event necessary for the state to show as to how the records moves, so as to satisfy the concerns of the court that there had been proper and due application of mind on the part of the authorities concerned. In my case, I was invited clarifications, given 7 minutes time, work order issued. So utter non-application of mind, apart from, my lord, that hot haste. Then, my lord, I am inviting, my lord, another decisions, my lord, reported in 2017-4, 2017 volume 14 Supreme Court cases, 642, my lord. That the action taken in great haste is arbitrary, and the action taken in the nature of knee-jerk reaction to the situation. See, this is, my lord, absolutely knee-jerk situation. See, issuing administrative circular, in inviting clarifications everywhere, my lord. Paragraph 9 and 15, my lord. This journalistic language was used by the Supreme Court, knee-jerking, my lord. Here, this is absolutely knee-jerking situation. Paragraph 9, my lord. The identification,
Yes.
let's say got it, paragraph 9. The identification, moreover, has been done only for the purpose of admissions in postgraduate courses, contrary to the guidelines in DS 1, that it must be based on general criteria applicable to other government schemes also. The report of the committee was submitted in one day and immediately accepted. The conclusions of the High Court that it was done in great haste, therefore cannot be faulted with. So therefore, the Supreme Court found that the order passed by the quashing by the High Court did not find any fault, my lord. Then, my lord, para 15. At page, my lord, internal page 16, para 15. 650, para 15. The conduct of the state issuance, I got it, my lord, your lordship.
Yes.
The conduct of the state in issuance of the notification dated 5th May 2017, based on no date, formulations of the same in a day, implementations before publications in the Gazette, after publications of NET, reflects inadequate preparation by the state, acting more in the nature of a knee-jerk reaction to situations. It does not meet the approval of the court. So, my lord, my lord, instant circumstances is absolutely, my lord, knee-jerking circumstances, my lord. That apart, my lord, I have got, my lord, 2 more cases. It is not required, my lord, that the service of notice, my lord, if the administrative circular, if it is challenged, my lord, then the notice, service of notice upon the Attorney General is not required. My lord, it is as your lordships is well aware, my lord, you're under, my lord, the Civil Procedure Code, my lord, under Order 27, my lord, Rule 8A, possibly, my lord, that the requirement of service notice when the important questions of constitutional law is involved, my lord, either under, my lord. So therefore, so this is notice is not required, my lord. So that is the findings of the trial court, my lord.
Yes.
And my lord, that the judicial propriety, my lord, I have one judgment, but I'm not showing it, my lord, that the learned court should have waited, my lord, till the outcome of the appeal, my lord. So this my respectful submission. So my this is my submissions, my lords. Under these situations, my lords, It is absolutely clear, my lord, abundantly clear, my lord, that the evaluations committee, my lord, had acted, my lord,
Yes.
say, my lord, in a what haste, my lord, and my lord, arbitrarily, my lord, and the pick and choose, adopting pick and choose policy, which is absolutely impermissible, starting from, my lord, the International Airport Authority, followed by Tata Steel, a lot of cases, my lord, till, my lord, that the up to, my lord, 2022, my lord. So therefore, my lord, this law is well settled, my lord, that the actions of the, my lord, that the, when they're granting state largesse, my lord, that their actions must be structured by non-arbitrariness, unreasonableness, my lord, and fairness, my lord. That requirement is absolutely absent, my lord, in this rule.
Yes.
So that's
Yes,
why
Mr.
respect.
Thank you. Yes. Mr. Yes, yes.
My lord, another, my lord, my learned friend is insisting, another, my lord, that the power of the evaluations committee, my lord, 2001, my lord.
Power of the evaluation.
Yes, 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 yes. 24-25.
Patel Engineer.
Paragraph 24, 25, 26, my lord. Yes, my lord. On the questions of discrimination, change of completions of bid cannot be permitted, my lord, by the evaluation committee, my lord, at page 24, my lord. The para 24, the controversy in this case has arisen at the threshold. It cannot be disputed that this is an international competitive bidding which postulates keen competitions and high efficiency. The bidders have or should have assistance of technical experts. The degree of care required in such a bidding is greater than in ordinary local bids for small works. It is essential to maintain the sanctity and integrity of process of tender bid and also award of contract. The appellant respondent number 1 to 4 and respondent number 10 and 11 are all bound by the ITV, which should be complied with scrupulously in a work of this nature and magnitude, where bidders who fulfill pre-qualifications alone are invited to bid. Adherence to the instructions cannot be given a go by branding it as a pedantic approach. Otherwise, it will encourage and provide scope of discrimination, arbitrariness, and favoritism, which are totally opposed to the rule of law and our constitutional values. The very purpose of issuing rules and instructions is to ensure their enforcement test the rule of law should be a casualty. Relaxations or waiver of a rule of condition, unless so provided under the ITV by the state or its agencies in favor of one bidder, would create justifiable doubts in the minds of other bidders, would impair the rule of transparency and fairness, and provide room for manipulation to suit the whims of the state agencies in picking and choosing a bidder for awarding contract, as in the case of distributing bounty or charity. In our view, such approach should always be avoided, my lord. Then, my lord, paragraph 25, my lord. For all these reasons, in such a highly competitive bid of global tender, the appellant was justified in not permitting respondent number 1 to 4 to correct the errors of the nature and the magnitude which, if permitted, would have given a different complexion to the bid. The High Court are in directing the application to permit respondent number 1 to 4 to correct the errors and to bid documents. So how, my lord, this, my lord, in the instant case, they were allowed to improve these positions, my lord, when he was not, he was rejected in technical commercial bid, my lord. How he was allowed to, my lord, participate in a financial bid, thereby improving his, my lord, but the complexions of the bid, my lord, this is not permissible.
That resolution is not been implemented. Yes.
So this is my respectful submission.
Yes, Mr. Ghosh.
Lord, what I understood, my lord, very short time, my lord. But kindly take, my lord, the prayers in the writ petition at page 75, my lord.
Page 75.
The prayer in Crux, my lord, they have challenged the circular dated 30th September 2022, which is, my lord, annexed at page 83, my lord. This circular is, my lord, issued by, my lord, the government of India for all the states, my lord. This circular, but I am for the state, my lord. This circular is binding on us. And he has agreed by this circular. What learned trial just said. Issue a notice to the, my lord, the
Attorney General.
to the Attorney General, or my lord, sometimes my lord, under additional Solicitor General appear, and my lord, to defend their circular. Unless and until these circulars, my lord, quashed, resigned, called, my lord, state is bound by that. Number one, my lord. Number two, my lord, these judgments of undue haste, knee jerking, all are, my lord, for the, my lord, tenderers who are in the, my lord, the zone of consideration. My lord, these petitioners could not, my lord, arrayed in the zone of consideration because, my lord, he has not applied within the time, my lord, as stipulated in the circular. So, my lord, these judgments will not apply, my lord, because he has not applied, my lord, he is not in the zone of consideration, my lord, in the tender. And, my lord, kindly take, my lord, under trial judge order, my lord. That is, my lord, page 221. It is yet to be decided. So, my lord, intra-court appeal, my lord, I don't think, my lord, kindly take, my lord. Page 221 of the, my lord, the state application. Or may I read for your lordship? Learned counsel appearing for the petitioners prays for an adjournment. Once again on the ground that the appeal preferred by the petitioners from order of such and such is pending before the division bench. This ground is also taken on that last occasion. The order from which appeal was filed was simply a direction on the petitioner to serve notice of the writ petition to the learned Attorney General of India, since the petitioners have challenged the circular issued by the central government. That is my humble submission also, lordship. The petitioners is taking time on every occasion on the ground of pending appeal. The matter could be, my lord, finished before the, my lord, under trial judge by this time, my lord. They took time, my lord, time and again, my lord, twice, my lord, what from a transfer from this order, my lord. My lord, it could have been, my lord, solved because, my lord, circular is under challenge. They are agreed by the circular.
What do you say about that allegation that they were called for?
My lord, because, my lord,
it's a discussion or clarification.
My lord,
page 200.
Clarification because they have applied within time. The person, my lord, clarified and applied within time. My lord, this petitioner cannot challenge our action because he has to prove, because it's a tender matter, he has to prove, and my lord, that he is within the, my lord, zone of consideration, my lord. First, my lord, the license has to be applied within a cut-off time. I don't know, my lord, why he couldn't have. 2020 circular till September 2022, he didn't apply. Now, my lord, he cannot say before a lordship that, my lord, I have someone is, my lord, preferred. That is malice. But I have to prove my bona fide first, then, my lord, I can challenge the malice. Though there is no malice, my humble submission before lordship. These are my respectful submission. My another submission is, my lord, this order, my lord, under the clause 15 of the, my lord, this order cannot be, my lord, assailed before your lordship in our intra-court appeal.
We have heard so and so, judgment reserved. What is the other appeal number, sir? We'll club that
Yes,
also.
Lord, the appeal number
It is
906 minutes running in the monthly. So
We'll club that along with 906.
Yes.
Judgment reserved.
I'm grateful to your lordship.
I'm grateful, lordship.
I've got the privilege, Lord, that a fast Lord of your assumptions of new office.
Serial number 8.
Number
My lord,
Serial number 8.
My lord, I am appearing for respondent numbers 1, 2, and 3.
1, 2, and 3. Union
Farakka
Barrage Project Authority.
4 and 5 are the contractor. In this matter, my lord, I appear for the appellant, but today, my lord, I pray for accommodation today.
Why?
My lord, due to my illness, my lord, I could not prepare myself. Your lordship, kindly take up this matter next week.
No, there is no urgency as such because the tender has already been granted to the successful bidder and they are continuing with the work. And in fact, the impugned order is also expressive of that. That on the ground of balance of convenience, there is no urgency.
It is what for operating a boat, is it?
Operation and maintenance of motor ferry boats in the river channel in Murshidabad.
Ganga, on the river Ganga, Ganges.
Under the Farakka barrage.
Under the Farakka barrage project.
At the request of the learned advocate for the appellant, list after vacation, you give it. You mark their appearance. Let it come after vacation.
Well,
After
after that.
21st June. Serial number 9.
I am grateful to Lord.
State is the appellant in the matter.
I'm appearing on behalf of the writ petitioner.
Malad, before I going into the Malad, the order of the Malad trial judge, Malad, kindly take the Malad the prayer in the writ petition, Malad. That is at page 38, Malad.
Advocate record second.
Malad, an order directing Malad from prayer B. A is the Malad the writ rules Malad for Malad expertise Malad that was not granted. Directing the respondent authorities to show cause as to why the security guard provided to the petitioners, namely Sri Deepak Bhomik, being a constable of police, was withdrawn from the duty of providing security to the petitioner without any prior information to the petitioner and without providing any alternative or substituted arrangement. And upon hearing the cause, that may be shown, and upon perusal of the records, that may be produced, and in the event no show cause is shown, this honorable court may direct the respondent authorities to provide the petitioner at the earliest such security arrangement he is entitled to. Malad, kindly take the interim order first. Malad. This is an interim order, Malad. That is at Malad page 42. Page 42, Malad. An interim order directing the respondent authorities to immediately provide the petitioner such security arrangement as he is entitled to. But my first ground is, Malad. My learned trial judge asked Malad to give security arrangement to the petitioner by an interim order. Matter is pending. So, Malad, this interim order is in the nature of a final order. That is my first Malad submission. My second submission is, Malad, the petitioner was retired from service 11 years ago in the year 2011. Malad, every 6 months, state, Malad, inquired about the threat perception. Malad, their case is that the petitioner, Malad, makes such certain comments in the Malad the television against the Malad the ruling party. That is why Malad security arrangement has been withdrawn. That is their case. My case is, Malad, 7% security arrangement has been withdrawn, including this petitioner, Malad. These security arrangements are, Malad, provided, Malad, when, Malad, there is any threat perception against such person, Malad, retired person, Malad. There is no entitlements anywhere. So, Malad, there cannot be any mandamus if there is no, Malad, entitlements, Malad. So, Malad, these points I can urge if, Malad, learned trial judge, Malad,
he was provided.
He was provided.
See, you are right. There is no vested right.
Yes,
we cannot say I have to be always with 2 policemen on my left and right. With the armed policemen should be. In your opinion, you said that though this man is Inspector General of Police, he retired long back, there is a threat perception.
Yes.
Therefore, 1 constable was granted.
Yes.
And who will pay for the constable?
No, Malad, state.
State will pay. So that continue.
Yes, Malad.
Suddenly you withdraw. Maybe 6 others also withdrawn.
Yes, Malad.
But how do you assess the threat perception?
Malad, that I could have filed a affidavit in opposition before the Malad learned trial judge, Malad, annexing all the Malad threat perception.
You say it's an interim order or
It's
final?
an interim order, Malad. An interim order in the nature of a final order, Malad.
No. See, you are right. The general principle is the interim relief cannot be granted, which is akin or similar to the final relief. That is general principle. But here is a case. You withdrew the security arrangement. Provided. If he doesn't get an interim order, writ petition will become infructuous.
Malad, may I? Malad, in the month of January, Malad, it has been withdrawn. Today, Malad, we are in May. There is no allegation of such.
You file your affidavit in opposition. We will direct the matter to be listed in June immediately.
Malad,
let 1 policeman go along with it.
Malad, may I, my humble submission before your lordship, Malad, 1 policeman is not a problem, Malad. Everyone having a 1 policeman, Malad, I could have, Malad, I will enjoy it, Malad. That Malad raise my status symbol.
You are mistaken, Mr. Ghosh. It's not enjoyment.
Well, this case, this is an enjoyment, my lord.
You had try having one policeman.
And this is a necessity. My humble submission, this is a necessity, my lord.
Direct, Mr. Devashish Ghosh will be provided with one armed policeman.
It
will be a clear invasion of your privacy.
Absolutely, my lord.
The big problem.
That is my humble submission before lordship.
I don't think it is a enjoyment.
My lord, may I state, my lord, what
And my
happened
lord, the
in this case?
necessity, this is a my lord, now the my lord, the status symbol, become a status symbol of the my lord, the some persons, my lord.
Fellows are like that. What?
And my lord, kindly record one thing, my lord. This is no nexus between his comment and my lord, the withdrawal of security arrangement.
The learned single bench will decide. You file your affidavit.
And now the contempt is my lord, running, my lord. They filed a contempt, my lord.
Unless you comply with it, you will be charged of contempt.
My lord,
And contempt at the instance of a former Inspector General of Police. Why all this?
11 years, my lord, former means my lord is not a my lord,
All right,
suddenly.
this intra-court appeal.
But kindly grant, my lord, within a week, my lord, we will file, my lord.
Heavens won't fall. There are so many urgent matters.
I know, my lord.
One
But my lord,
fellow, go with him, let him go. As if he'll protect his life.
so my lord,
He'll
kindly,
be the first person. to
then my lord,
survive.
kindly extend the time whereby my lord, contempt, my lord, for the purpose of contempt, my lord, kindly extend the time for the my lord to give him.
We'll extend it by 3 days.
Yes, my lord. I'm
The,
grateful.
This intra-court appeal by the state is against an interim order passed by the learned single bench in WPA 4521 of 2023, dated 10/4/2023. By the said order, the appellants were directed to give police protection by allotting one police constable to the writ petitioner, who is a retired Inspector General of Police. The Mr. Devashish Ghosh, the advocate appearing for the state, would submit that the relief granted by the learned writ court is in the nature of a final relief granted in the main writ petition, much before affidavit in opposition could have been filed by the state. As a normal proposition, the said submission would merit acceptance, but there may be cases where the cases where interim protection may be required to be granted in certain cases where there is a likelihood of the main matter becoming infructuous if interim protection is not granted. Which will be in aid of the final relief. The learned single bench, while exercising discretion, has passed the interim order. As an as an appellate court, we are not inclined to interfere with the order. Full stop. It is always open to the appellants to file their affidavit in opposition and argue their grounds that the withdrawal of the security provided to the writ petitioner was justified and was not for any other collateral purpose. This issue will obviously be adjudicated in the pending writ petition. Hence,
No, there was no direction for everyone in opposition. Kindly give us the direction for me.
Hence, we do not find any ground to interfere with the impugned order. Accordingly, the appeal is dismissed. Our appellants are directed to restore the security back to the writ petitioner within not later than 15/5/2023. Full stop. The time granted for filing the affidavit in opposition, no direction. Report. All right. Since the learned writ court had only called for reports, it is always open to the appellants to file an appropriate report before the learned writ court, which will be considered on merits and in accordance with law. With the above observations, appeal dismissed. Next.
I'm grateful. Serial number 10.
Yes.
This is my application, your lordships. My lord, the petitioner, the appellant before your lordships, my lord, carries on business, my lord, and has a facility, Hujan's bill discounting limit facility, which is secured by LC, my lord. with the respondent bank, Karur Vysya Bank. Now, my lord, there was a scheme floated by the, my lord, NCGTC, National Credit Guarantee Trust Corporation, my lord, whereby the entities who were having, I am an MSME, who were having an my lord, a working capital term loan or a subsisting loan, and there was, my lord, no default there, etc. My lord, 20% of that amount, GECL, guaranteed emergency credit line, under that scheme I was entitled to that. Now, my lord, may I also indicate that I will take your lordships to those provisions, my lord, under the scheme, this was an auto sanction. That means opt-in, opt-out option was given to us. If we require, we will say that we do not want to take this option. So it is an auto sanction, my lord. Now, my lord, we did not receive that sanction or the disbursal of that extra GECL, which was contemplated under the scheme. The scheme's name is ECLGS, Emergency Credit Line Guarantee Scheme. Now, my lord, we had approached this honorable court, the honorable single bench. We did this writ petition saying that, my lord, this disbursal should be made. Now, my lord, by an impugned order before your lordships, though the petition was held to be very much maintainable against the private bank, and my lord, I am not, my lord, here to assail that, of course. My lord,
we may pose that question to you.
Yes, my lord, I will try to satisfy your lordships on that point also. Now, my lord, I am aggrieved, my lord, by the observation that, my lord, may I take your lordships to the impugned order first, my lord?
Yes.
Yes. My lord, may I take your lordships to paragraph number 9 directly?
Please.
Yes. Now, my lord, the relevant dates, however, assume importance for assessing whether the petitioners have established a case for relief on the merits of the matter. The first rejection of the bank was on 19th October 2020, followed by the second communication of 3rd November 2020, and the last communication is of 16th November 2020. By all these three letters, the respondent bank made it clear that the petitioners are not eligible for the scheme. The petitioners' replies to these rejections are of 27th October 2020, 9th November 2020, and 5th December 2020, amongst others. The last letter on record is 2nd May 2022. Lord, this date is of importance, where the petitioners relied on FAQ clarification number 94 to substantiate their claim under the scheme. Learned counsel appearing for the petitioners submit that there is an urgency in the matter since the ECLJ scheme shall remain valid only till 31st March 2023, which was the last date of sanction, which is precisely 2 days away from the last hearing of the matter. The writ petitions were, however, filed on 2nd March of 2023. This court does not find diligence on any steps taken by the petitioners immediately following the letters of rejection, the last of which was given on 16 November 2020. There are no documents to show that the petitioners were pursuing their remedies before any forum in support of their claim. The palpable silence after November 2020 or at least after May 2022 goes against the petitioner. The petitioners have not shown any promptitude to corroborate the plea of urgency, which is now being taken before this court. Now, my lord, this is reason number 1. Reason number 2 is immediately thereafter. The replies, rejections of the bank in any event raise questions which are disputed, convoluted, and evidently matters which cannot be adjudicated in a discretionary jurisdiction under Article 226 of the Constitution. This court hence does not see any reason to exercise its discretion to grant relief as prayed for, and accordingly the writ is dismissed, my lord. Now, my lord, as I had already said, my lord, what transpired before the honorable single judge was that my last letter was on 2nd of May 2020. Thereafter, I have
How to go into all these facts? See, suppose
yes,
this is some scheme which the Reserve Bank has announced. The
Yes.
bank is adopting that scheme.
Yes.
There are several schemes announced to NBFCs also.
Yes.
And
Just like this one
some
also.
commercial wisdom, etc. In a writ proceedings, merely impleading the Reserve Bank of India, Union of India. How do you ask us to issue a writ of mandamus? You consider it in this?
Yes, my lord. So, my lord probably is, my lord wants me to.
No, what is the consequence of this?
My lord, I say,
You will become a non-performing asset.
my lord, I will have, my lord, I say that the purpose of the scheme was of a public purpose to ensure that all the businesses in India during COVID, my lord, the hit they have suffered, they can come out of it. This purpose would fail as against me.
All right. 16th November 2020. Where is that last rejection?
Yes, my lord. My lord, the last rejection your lordships will find, my lord, at page 239. 16th of November 2020. And may I read? With reference to your request letter dated so and so, upon placing the request with our functioning authority, is informed by the authority that as per RBI guidelines, bills purchased, discounted, negotiated under LC will be treated as an exposure on the LC issuing bank and not on the borrower. RBI master circular dated so and so is enclosed for your ready reference. Hence, we regret to inform you that Mrs. Joyki Merchandise Private Limited is not eligible for working capital term loan GECL scheme issued by Government of India. So this is the reason.
And they refer to some condition in the
My lord
RBI
will find that
guidelines.
enclosed just in the next page, my lord. That
Yes.
is what they have said, that they have relied on this.
Actually, these are all guidelines in the sense, there are one set of guidelines as to how you declare a account as a stressed asset.
Yes.
How you declare it as a non-performing asset.
Yes.
That may have a different impact.
Yes.
Because even recently Supreme Court has said, declaring a person as a non-performing asset is a very serious matter. But here, if you go by the language used, it says banks may adhere to the following guidelines while purchasing, discounting, negotiating, rediscounting of genuine commercial trade bills. Since banks have already given a freedom to decide their own guidelines. So they will issue some guidelines, and Reserve Bank of India, if the bank wants to adopt, they adopt. They want to tweak the guidelines better, they are at willing.
Yes.
And how we
My
can't.
lord, I understand what is passing through your lordship's mind, but may I take 2 or 3 points very quickly, my lord. The first thing is RBI has got nothing to do with the scheme. My lord, the scheme was floated by NCGTC. My lord, through the government had chosen this organ to float this scheme, my lord. And the scheme guidelines and the frequently asked questions of the FAQs which were given after the scheme are completely comprehensive. And under that scheme, only the NCGTC has got the power to decide on these issues.
The scheme had come to an end on 31st March 2023. 2 days before that, you filed the writ petition. Your last rejection was 2020.
Yes,
You should have.
That is an issue I will have to overcome, my lord. I am aware of that.
Difficult issue.
My lord, if I may first take your lordship through the entitlement that I have.
First, we cannot adjudicate this matter at all in a writ petition. Impossible to adjudicate. The bank, in its wisdom, commercial wisdom, says they have framed a policy.
Yes.
And they say given they have been given the freedom.
Yes.
And what discounting they have to do. This is all pure commercial transactions. And how to.
Yes.
And now even assuming your writ petition is allowed.
Yes.
We cannot issue a direction to the respondent bank.
Lord, probably your lordships can, my lord, because the last date of disbursal is on 30th of June 2023.
Once the scheme gets locked, disbursal can take even 1.5 to 2 years. There may be various issues.
Yes.
That no court can say, revive the scheme. If probably on disbursal,
yes,
or after your offer was accepted,
yes,
if there is a withdrawal, saying that for such and such reason, we erroneously granted you the relief.
Yes.
Now we withdraw. Then you challenge it in dates back, but not.
But my lord, if I may also indicate that, my lord, it is an auto-sanction loan. It was an opt-out
Right,
option.
sir. Without the bank, he is your partner. He is your financier. Without him, you can't do anything.
May I only take your lordships to one,
No,
my lord.
I think we have heard you enough.
My lord, only one FAQ, my lord, for my satisfaction, my lord. I am
please.
At page 147. My lord, they say that this bill discounting facility, my lord, it does not entitle me. My lord, at page 147, my lord, may kindly take up question number 94.
Whether limits sanctioned under bill discounting facility, which is short-term but rolling over facility, is eligible for so-and-so assistance based on outstanding debts, are given to purchasers, sellers. Such limits given to purchasers only replace the debt due to the suppliers. It does not affect their working cap cycle. Hence, only based on if supplies will be eligible to so-and-so assistance based on the outstanding facilities on the reference.
Yes. Now, my lord, it is not in dispute that I'm a supplier. It is not in dispute that there was a facility already existing with the bank. As far as bill discountings are concerned, my lord, the only distinction is whether I'm a supplier or a buyer.
How do you claim a right that your bill has to be discounted? It's a pure discretion.
No, I don't claim that.
No, unless and until you say that I am entitled to with my banker if I produce a commercial or a trade bill that he is mandatorily required to discount it. No, he
No,
can. He
of
can
course,
refuse.
and we are not on that. Neither I nor the respondents.
So therefore, if that is not so, no, there is no vested right with the account holder
My lord, this
or the LC holder.
I say, I demand the, my lord, stand here before your lordships for the GECL facility, which is to be disbursed under the scheme. The prerequisite is I must have a loan with the bank concerned.
But this
That I have a loan with the bank concerned is out of question. Whether the question is whether now I am entitled to the GECL or not.
For 3 years, you did not pursue the matter.
My lord, I had, my lord, written to NCGTC and all other several authorities. I, my lord, admit that I could have come to, instead of doing that, I could have come to court directly. But, my lord, May 2022 is not the last date of my efforts, my lord. It will appear from the, my lord, annexures itself. I can take your lordships to the page 70.
No, sir,
Yes.
we have heard you, sir. Sorry, sir.
My lord, as late 2022, even after the date which has been taken, my lord, note of by the honorable single judge, my lord, I had been pursuing my remedies before all the authorities, including NCGTC. And, my lord, if I may only last on one point, since, my lord, the NCGTC decides who is entitled and who is not, my lord, may I also beseech your lordships to only put this question to NCGTC, that what is their opinion on this? Because, my lord, if I may say why I am saying this, the very next item is exactly similar, where the appellant has been actually given this benefit by another bank. And NCGT has said yes to that. All the conditions are same.
The next matter we will see. This intra-court appeal by the writ petitioner is directed against the order dated 31st March 2023 in WPA 5454 of 2023. The said writ petition was filed by the appellant, praying for varied reliefs. And when we went through the relief sought for in the writ petition, we find that the relief is against the first respondent bank, first and second respondent bank, which is a scheduled bank and not a nationalized bank. The petitioner seeks to give the appellant seeks to give a color to this litigation by referring to a scheme which has been formulated and made known to the public called as ECLG scheme. The appellant's case is that they are entitled to the benefit of the said scheme, being an eligible borrower as defined in clause 4 of the scheme and the operational guidelines updated as on 6th October 2022 by the National Credit Guarantee Trust Company within bracket NCGTC. The learned single bench, though the learned single bench noted that the respondent bank is a private bank, and the submissions of the respondent bank with regard to the maintainability of the writ petition was raised. The learned single bench was of the opinion that the said scheme was floated by the Ministry of Finance, Government of India, for providing 100% guarantee coverage for additional working capital term loans in case of banks and financial institutions, and additional term loans in case of non-banking financial company up to 20% of their outstanding credits as on 29th February 2020. The scheme also provided for various other framework. The learned writ court was of the view that the respondent bank, being a member of the lending institution under the scheme, is consequently drawn within the obligation and duties incorporated there. And the learned writ court was also of the view that the object of the scheme elevates the scheme into one with a clear public element for preserving small and medium businesses following the pandemic. Therefore, the learned writ court opined that the role of the respondent bank cannot be seen within the limited parameters of a private financial institution. In our considered view, we do not fully subscribe to the findings recorded by the learned single bench with regard to the maintainability of the writ petition. However, since the respondent bank has not preferred any appeal, we do not wish to express any opinion on that. Reverting back to the manner in which the appellant had pursued the matter, we find that the request made by the appellant was first rejected by the respondent bank on 19th October 2020. The appellant appears to have reiterated his request, which was rejected on 3rd November 2020. And finally, on 16th November 2020, the further request was rejected. In all these communications, it has been mentioned that the appellant is not eligible for WCTL-GECL scheme issued by the Government of India. Admittedly, the scheme has come to an end on 31st March 2023, and the writ petition was filed at the fag end of the expiry of the scheme, as noted by the learned single bench, 2 days before the scheme came to an end.
Milord,
No.
just 1 month.
Oh,
The hearing was
1 month.
conducted.
The learned judge says 2 days.
That is the date of hearing. It was filed. That is also
about
recorded.
1 month from the date of expiry of the scheme. On going through the one of the orders of rejection, namely 3rd November 2020, the respondent bank has referred to RBI Master Circular dated 1st July 2015. On reading of the said circular, it is seen that the guidelines are recommendatory in nature because it gives enough leverage to the lending institutions to adhere to the guidelines while purchasing / discounting / negotiating / rediscounting of genuine commercial / trade bills. The circular further states that the banks have already been given freedom to decide their own guidelines for assessing and sanctioning the working capital limits of borrowers, etc. Furthermore, the bank has been given liberty to lay down clearly a bill discounting policy approved by its board of directors, which should be consistent with their policy of sanctioning of working capital limits. And there are further other suggestions, recommendations made in the circular. Thus, the circular clearly indicates that the respondent bank, more particularly a private bank, has been granted full autonomy to frame its own guidelines while purchasing / discounting / negotiating / rediscounting of genuine commercial / trade bills. Therefore, given the factual scenario, a writ court cannot be called upon to examine these financial niceties, which are best left to the lending institutions. Therefore, we agree with the ultimate conclusion arrived at by the learned single bench, stating that the writ petition cannot be entertained, cannot be, the ultimate conclusion of the learned single bench that no relief can be granted in the writ petition. As pointed out earlier, we are not fully in agreement with that portion of the order passed by the learned single bench, where the maintainability of the writ petition, considering the subject cause of action. With the above observation, appeal dismissed. Sorry. Next.
Serial number 11.
Lord, this is. Lord, again, I will only trouble your lordships, Lord. In this matter, I have also identical matter. As I have only indicated before lordships that my eligibility to the Lord.
No, you perceive this RBI guidelines started to come because of lot of loans becoming NPAs, and banks had to write off.
Yes.
And you would have seen in the last 5 to 7 years, there are a lot of banks have been closed. Mergers have taken place. So therefore, the body, and what is it called? DRB or something, DB. There's one in the Reserve Bank of India.
Yes.
There's one division which deals with that. Even in that circular, you can find in the
Yes.
bottom.
DCRB probably.
DCRB or something. So they periodically review the based
The health
upon,
of the bank.
yes, based upon the budgetary provisions, etc.
Yes.
But it's very, very difficult. So if at all, see, that's why we asked you a question at the commencement, that if as a consequence of this, you have to be declared as an NPA, you will have liberty before the NCLT
Lord.
or before the debt recovery tribunal or something.
The condition is that the health of my existing loan account, which makes me eligible for the facility of the scheme, should not have been made NPA for the last 60 days, and I have qualified for that.
That's it,
Lord,
sir.
that shows that the health of my account is very good. Milord, I was just trying to impress your lordship on that. The case, Milord, the only additional point probably I will have in this matter is that the exact terms on which I have been, Milord, denied the facility by this respondent bank, another bank, which is the federal bank, has, Milord, been pleased to grant me the facility, and the NCGTC has also
shift your account to federal.
Milord, I
bank with them.
From this, Milord, I only
But you
say
know one thing, Karur Vaisya Bank, it's very strong in terms of asset base. A lot of people won't know.
Milord?
In terms of its asset base, it is very, very strong.
Very strong bank, yes.
And a lot of people won't know because Karur is a district in Tamil Nadu.
Yes.
And a lot of industries are there.
Yes.
But people will never guess that what is the strength of the bank. Really, it's a very healthy bank.
Strong financial base.
Very strong financial. And it has been, I think, completed 100 years or so.
Quite well known, Milord. Everybody knows about Karur Vaisya Bank, I believe. I heard of it. So, Milord, only
what do you want to do?
Milord, only thing is, Milord,
so give
since I say that I had a similar Milord bill discounting facility with Federal Bank, and even on that I have been granted the, Milord, benefits of the scheme once, which the NCGTC has approved. Milord, that only shows that those, Milord, that exact same, Milord, situation cannot be taken by the Karur Vaisya Bank.
Identical order, is it?
Two different banks.
Exactly.
Two different situations. Lots of that.
All right. This intra-court appeal by the writ petitioner is directed against order dated 31/3/2023 in WPA 5454 of 2023. The learned single bench had dismissed the writ petition on the ground that no relief as sought for can be granted in a petition under Article 226 of the Constitution of India. Identical order was passed in the case of one Joy Key Merchandise Private Limited.
The previous matter.
And the writ petition was dismissed, as against which the writ petitioner preferred appeal before this court in MAT number 700 of 2023, which was dismissed by judgment dated 11th May 2023. The operative portion of the judgment is quoted here and below. After that is typed, you can quote it. In the light of the, next para. The learned advocate appearing for the appellant submitted that there are certain factually distinguishing factors in the case on hand, more particularly that what was rejected by the respondent Karur Vaisya Bank was granted by another bank. If that be so, it is for the appellant to take a commercial decision in such financial matters. In any event, we find the question on which the appeal in MAT number 700 of 2023 was dismissed is no different from the case on hand. Therefore, this appeal stands dismissed. Thank you.
Milord, only if I may trouble your lordship, one thing. One submission I had made, Milord, if it deems it fit before your lordship, it may be recorded that the RBI has got nothing to do with the scheme. All the decisions are, my lord, laid down by the NCGTC in its scheme and the FAQs.
I
That is
got issues
comprehensive.
with this point, your lordship, because the loans which are sanctioned by any bank is governed by RBI, your lordship. So whether the decision, whether to grant or not, the facility that is based on the loan, the facility already existing, your lordship. So this cannot be said, this cannot be argued that RBI has nothing to do with the scheme, your lordship.
In between, in the first matter, that is item number 10, the learned advocate appearing for the appellant's content submitted that the Reserve Bank of India has got nothing to do in the subject matter, and it is a scheme which has to be looked into. The learned advocate appearing to the respondent bank would submit that the lending facility itself is being regulated by the guidelines issued by the Reserve Bank of India, and it will be incorrect to state that the scheme has to be extended to the appellant, dehors the guidelines issued by the Reserve Bank of India. This one sentence.
Your lordships.
Yes. Next.
Serial number 12.
12 million, I beg to appear for the state respondent lordship.
Yes, my lord, I beg to appear on behalf of the applicant.
For the college. To me, the issue. That's it. Yeah.
So this is the affidavit of service. Adjustment number. Sure.
Yes, sir.
Yes, my lord, may I submit one thing? My lord, in an intra-court appeal, my lord, the first part of the order of the my lord, single bench, that we are not the ex-students, we are the students, number one. Number two, my lord, the order latter part, my lord, if your lordship kindly sees in the order that the honored single bench has been pleased to send the same for the clarification, that is in respect of the page, internal page 2, paragraph 5, the order, last part. The only condition which may need clarification, that there shall be no commercial stalls except the stalls related to the Rabindranath Tagore. But this clarification, we are to go before the committee itself. Now, my lord, if your lordship kindly sees what the committee has observed initially, that is at page, my lord, I'm just giving, my lord, that is at page, my lord, 55. No, sorry, my lord, page 79. Page 79 of the stay application. My lord, members present, my lord, at the top, my lord, that is Sri Shuprakash Giri, president of the governing body of the college. Now, my lord, they have indicated everything in page 79, thereafter page 80. Just, my lord, turn to page 80 once. There will be no rent for using college ground for organizing the Mela this year. Very good and welcoming. Because last year they have taken 3 lakhs, they have remitted the same this year. I have annexed the document. The Mela will be conducted for 45 days. Total area to be used for Mela, 5,000 square feet, subject to a lordship's kind sanction, if I am not wrong. Probably to some extent, extra of this particular room of the 5,000 square feet. A fair is to be conducted, they have allowed in a 5,000 square feet. But whether it is possible or next to impossible. Now, my lord, there will be no commercial stall except the stalls related to Rabindranath Tagore. My lord, if I sell it out, a book of my lord, Rabindranath Tagore, then also there will be a commercial transaction. I have prayed before the court below as well as before this court that 5,000 square feet, my lord, if it comes, my lord, 5,000 square meter,
No. If you are not, if it's not possible to conduct it here, go and conduct it elsewhere. What is your right, sir? You are students who are studying in the college, ex-students are also there, you have joined together. You want to conduct a Mela, and this college makes a governing body. There is some direction issued in WPA 9686.
Yes, my lord, that is, my lord, at page, my lord, yes.
It is an aided college or only a recognized government college?
Recognized government college.
Government college.
Government.
So therefore, this Mela should not be conducted.
Then, my lord,
We will
kindly
say
observe
that-
this thing, that henceforth no Mela should be conducted in this particular area concerned. My lord, then, my lord, entire.
Be happy that they have granted you, your students, and your students have to pass out, and they should get their, yeah. And you are challenging the managing committee's resolution?
No, my lord,
Making
what I am praying, my lord,
President cannot do that, secretary cannot do that. What the student will have?
my lord, the president, my lord, why, my lord, my submission before your lordship, instead of 5,000 square feet, if it
That
comes,
is a matter of negotiations.
my lord, we have tried.
But then be happy with 5,000 if you are going to show good footfall. And there are like the book fair we had. To go into one stall, you had to wait for 1.5 hours. Did you
Yes,
go?
sir.
You
I
went-
have the experience.
No,
to that
did you-
effect.
this year did you go to Salt
Yes.
Lake? For going to one stall.
Since 1992, my lord, I used to go.
So there were so many book lovers who wanted to go in, crores worth of this year, the record sales in the.
If that is so, my lord, even then the crowd, kindly imagine about the crowd, whether in the 5,000 square
What is
feet,
this Mela?
my lord, there are functions as well as, my lord, there will be a stalls. Not only that, the kids section will also be there. This is the main purpose of the
No. What is the function?
function, my lord. It starts, my lord, on and from 8th May. Because as there is a
Vaishakhi all over.
On the Mela to review to Rabindranath Tagore. This Mela was supposed to be organized.
For such reason, I have obtained the link.
But only 100 meters away, the ladies hostel is there.
Definitely.
Kindly visualize the situation.
Rabindranath Tagore won't like this litigation in his name. Why this 5,000? Sir, I'll tell you, if at all you want to reach something to a person, it doesn't matter. Even if you have a roadside stall with probably a small table, after like normal our reading table, you'll be able to do it. Because I have seen that in the Legal Services Authority camps. Even in the book fair, we had two stalls, mediation and legal services. We have done that after I came here. We have done that in other districts, Murshidabad, Purlia, etc. We went remote districts. No infrastructure, but all that we were able to give is a small stool. So we got one towel, put it on there, and kept the pamphlets. You won't believe the number of people who came. There was so much of people were so ignorant. They were not aware of so many schemes are being there. Either state government schemes, central government schemes. So it is not, if at all you need to propagate, you don't require pomp, you don't require big establishments. It is the message which goes. That's my opinion. I may be wrong.
No, my lord, I cannot say that, my lord,
No,
because, my lord,
you
it's
can-
after all, my lord, it's the highest court of the state.
So therefore,
But what I am praying, subject to lordship's kind sanction, can it be, my lord, extended 5,000 square feet to 10,000? My lord, let them let them consider this thing, my lord, in this fashion. At least, my lord, we are in a good, my lord, there will be a good message to the society that we want to.
Once having dragged them to court before the single bench, division bench, I don't think so they will bow down. Next year, you definitely try. You'll have a different set of office bearers. Your present student would have passed out. It's a, what is it?
My lord, last, my lord, 5 years, my lord, we are continuing with this particular fair, and they have been granting the sanction. They have been granting the sanctions.
This intra-court appeal by the writ petitioner is directed against the order dated 27th April 2023 in WPA 10291 of 2023. There are 5 writ petitioners who are students as well as ex-students of a college, and they sought for permission to conduct a Mela. Permission was granted by resolution of the managing committee managing committee.
Governing body,
Governing body of the college, dated 24th April 2023. The governing body in its wisdom thought fit to grant an extent of 5,000 square feet to conduct the Mela for 48 days without charging any rent.
45 days.
45 days without charging any rent. The appellant's grievance is that the Mela cannot be conducted within the extent of 5,000 square feet, but larger extent would be required. Apart from that, no commercial stall except the stalls related to Rabindranath Tagore should be put up. It is a submission of the appellant that if books and material propagating the ideals of Rabindranath Tagore are offered for sale, that also may amount to a commercial transaction. In our considered view, there is no vested right for the petitioners to state as to what would be the extent of area that will be allotted for conducting the Mela, as it is the decision of the governing body. And such a decision cannot be subject matter of a judicial adjudication, that too in a writ petition under Article 226 of the Constitution of India. If at all the petitioners who claim to be students and ex-students seek for any larger relief from the governing body, it is for them to approach the governing body in an appropriate manner and litigate asked by the learned single bench. Sorry.
I'm grateful. Deeply amazed.
We'll stop with this.
Yeah. Postgraduate. ঠিক আছে।